All right, so now on to our speaker tonight. Harmeet Dhillon is the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. She was nominated by President Trump in December of 2024, confirmed by the Senate on April 3rd, 2025, and sworn in as Assistant Attorney General on April 7th, 2025. There will be a quiz later. Prior to joining the Civil Rights Division, Ms. Dhillon founded both the Dhillon Law Group, a successful legal practice that was in California, Florida, Virginia, New Jersey, and the Center for American Liberty, a nonprofit organization dedicated to pursuing civil liberties and legal claims. Her law practice focused on the First Amendment, free speech, civil rights, and campaign and election law issues. Now, moving forward, Ms. Dhillon and I will speak for roughly 30 minutes. We're going to have a back and forth discussion. At that point, we'll move to a moderated discussion period. So you will see one of our staff holding up a microphone, okay? You will line up if you wish to ask a question. You will line up in front of that student and get ready to ask your question. Please make sure your questions are brief. They are questions, they're not speeches. Do not take the microphone from the student ambassador, please. Let him or her hold it while you ask your questions. We will conclude promptly at 7 o'clock, and boy, am I excited to have this discussion. Thank you so much for being here. Would you please join me in welcoming Harmeet Dhillon? Well, thank you for being here. I think we're all really excited to hear some of your background, your discussion on some current topics of the day, and to learn a little bit more about the Department of Justice and the Civil Rights Division. So let me start off with kind of a general question, maybe an easier one. Tell us a little bit about your background and why you accepted this position.
Well, thank you for your warm introduction, and thanks to all of you for being here to hear about the work that we do at the Civil Rights Division. I came to the United States as a small child. I'm an immigrant. My father was a small-town doctor, orthopedic surgeon in rural North Carolina, so I grew up in the South. When I moved to Smithfield, North Carolina in 1975, there was a sign on the highway that said, the Methodist Church welcomes you, the Lions Club, the Rotary, and the Grand Dragons of the Ku Klux Klan welcome you to Smithfield, North Carolina. So that was Smithfield in 1975. That sign went away in 1976, but I went to public schools in small town and grew up in a religious household of a Sikh family. My father wore a turban. My brother still wears a turban. And, you know, we just were a sort of immigrant dream of coming here to have a better life, quality of life, but also pursue our religious beliefs without discrimination, which Sikhs had been facing in India. And so that's kind of my background. And I come from a family of doctors and no lawyers, no politicians. Those are considered to be kind of disgraceful professions in India. My one grandfather was a doctor and a general, and the other grandfather was a doctor who worked for the Indian Civil Service. And so I was quite a disappointment to my family going into the law as opposed to medicine. But that's kind of how I was raised.
Interesting. Well, you proved them wrong, right? No doubt about that. I'd like to talk a little bit about the office itself and your role there. So tell us, if you would, what are the office's priorities now, and maybe how do they differ, if at all, from previous office holders?
Well, let me step back a little bit. I did go to college as a pre-med, but I was a campus free speech activist at Dartmouth, and I was a conservative, and ended up suing Dartmouth when I was the editor-in-chief of the Dartmouth Review. And lawyers from the American Civil Liberties Union helped us in our challenges to Dartmouth's free speech codes. So my passion for free speech and civil rights goes back to my college days when I was a teenager. And so I went over to the journalism briefly and then went to law. And I've now for more than half of my life, I've done civil rights work as an attorney, representing people of faith, journalists, people who have been discriminated against by the government mainly. And so when the and also gotten involved in politics as well. So the president asked me to step up and take this position, and it was a big honor to do that, but it's also one of my passions. So it's something I've already been doing for most of my career. So I asked questions myself before I took this job, I'm sure like you did when you took your position here. And it was important to me that I do believe in our civil rights laws very passionately. So it was important to me that the job was going to involve enforcing those laws. And at the same time, in an executive branch body, you have to follow the policies of the administration. So you have to agree with them. And generally speaking, I've been a lawyer for President Trump as an individual and for his campaign and for some of his PACs at my law firm. And so I felt comfortable that, generally speaking, our views were aligned on these issues, and met with the Attorney General, who had, of course, been the Attorney General here in Florida, and, big fan of hers, and she's also someone who is very much about law enforcement and upholding the rights of all Americans. And so I asked those questions, I was satisfied, and I, stepped up to this job and was confirmed. I think the big change, if I were to encapsulate it in a sentence, between historically the Civil Rights Division of the Department of Justice, which goes back to the 1960s, to today, is that the Civil Rights Division of the DOJ has been known as a place where really the most liberal lawyers will go, spend their entire careers, and they'll focus on an aspect of civil rights law. And really kind of, if you name any particular area, and there are, I think, 12 or 13 sections that I administer, including employment, education, disability rights, housing rights, police practices, special litigation, and a few others. It's really kind of from a particular political perspective. And our president's agenda and my stewardship of the DOJ for almost a year now has been protecting the rights of all Americans. I believe all Americans are protected by our civil rights laws. The United States Supreme Court has held in 2 recent decisions, Ames versus Ohio, with respect to education, saying that, not education, but employment, saying that we don't have different standards for proving discrimination claims in the workplace if you're a majority plaintiff versus a minority plaintiff, very important principle. And secondly, Students for Fair Admissions, a couple of years before that, which was a landmark case involving Harvard, University of North Carolina, and some others, systematically discriminating against applicants in higher education admissions and saying that that's illegal under our federal civil rights laws. These 2 principles really guide how we at the Civil Rights Division today believe that any American who believes their civil rights are violated should have a fair hearing at the DOJ Civil Rights Division. That's a sea change and a landmark change.
Right. Thank you for that. One of the things that I want to do here is for the students and the young professionals in the crowd who are thinking about getting engaged at the DOJ and in civil rights cases, just a little bit about the kind of the nuts and bolts about the office itself, right? So how does the division find out about possible civil rights violations? And after we talk about that, maybe we talk a little bit about how you process them and move forward.
That's a great question. So I think the public perceives maybe the government as kind of their legal aid for their personal claims. And we do take on individual claims, and I was on the board of the American Civil Liberties Union. After 9/11, I was not a big fan of the Patriot Act, and I believe in our personal privacy. So what I learned in my years on the board of the American Civil Liberties Union is a concept of impact litigation. So even the ACLU cannot take every deserving case that comes in the door. You have to look at what cases you can pick that are going to have the massive or major impact on the most Americans with your limited resources. And that's a principle that we apply at the Civil Rights Division as well. We are not a substitute for private counsel, and most of our federal civil rights laws have provisions that include private rights of action, even attorney fee shifting, like Title VII has that, which encourages private lawyers like I did in private practice to take on cases on a contingency basis. And then if you win, you get paid. So I'm not a substitute for private counsel. So what we look at is what are the cases where you have a combination of a good set of facts, good legal claims, and either a fair hearing from the court or an opportunity to create a circuit split if you're trying to get a case to the United States Supreme Court. So in other words, different rulings in different courts. And so that's what we look at. Now, I'm very active on social media. I think you and I discussed that earlier. I have about 1.6 million followers on different platforms, mainly on X. And so I've been a prominent civil rights lawyer for many years. I've been on a lot of the major news networks. So people reach out to me, they tag me with interesting cases. So every day I open up X before I even get out of bed and get on the treadmill or go out for a walk, and I see what's happening. And sometimes I see things that are happening at American university or an American public employer or a city council taking down somebody's flag or something like that. And then I forward it to my team and we evaluate, and then I take their opinion. There are hundreds of lawyers who work at the Civil Rights Division, and I have leadership and 4 deputy assistant attorneys general, 1 principal deputy. And so I get their input. And I'm like the bad idea fairy sometimes, is what they call me in the office. They're not all bad.
Nothing wrong with that.
I send the ideas out, and then I get feedback from professionals who have a bigger bandwidth than I do. And they say, Harmeet, this is a good case. We're going to investigate it further. Or Harmeet, here's why this is not what it seems like. But we also get thousands of emails and letters from the public. And we also get hundreds of letters from members of Congress and United States senators every year. So they will often write to us about their constituents. We will frequently refer things. For example, someone may say, I have a constituent and he was deprived, he has bad conditions in his federal housing. And we'll write back and say, well, that's unfortunate. However, that's properly directed at HUD because HUD gives the grants for that program. HUD can investigate it, and if HUD finds that there's a violation of this person's federal civil rights, he can then refer it to us. So even though we have sections over all of these different areas, the way that the federal laws work is that any federal grant-making agency in the executive branch has a primary jurisdiction over investigating alleged civil rights violations relating to that situation. For example, the vast majority of the educational situations are investigated by the Department of Education. If they find there to be a violation, then they refer it to us. We have joint jurisdiction over matters where the United States Department of Justice itself may have given a grant. So I have personally, at the Civil Rights Division of the DOJ, we have given grants to certain educational institutions. So we don't have to wait for Ed to give us a referral. We can open up our own investigation. And there are a lot of things I'm interested in, but I don't have jurisdiction over. So we strictly follow what do we have jurisdiction over. If we don't have jurisdiction, I'll still try to connect somebody with a worthy cause to another agency. And then there are a few areas where we use our persuasion and our expertise, even though we don't have jurisdiction. So for example, there may be some regulation by the United States Department of War that impacts federal civil rights. For example, articles of faith that a person may wish to continue to observe, even though there's a beard regulation or a regulation involving wearing something on your head, a turban or a yarmulke. So in those types of situations, we offer our expertise. Sometimes I've called cabinet secretaries and expressed my concern about a policy.
I bet they love those phone calls.
Well, they're nice because I actually know these people from the campaign trail, and they're always very receptive, actually. And then we provide expertise to the general counsel of that agency, and we work collaboratively to try to solve problems in the government. And I think it's actually a very collegial environment. I've never had someone not take my phone call, including cabinet secretaries, same day, and not listen to what I have to say and consider it carefully.
That's good.
Yeah.
That's great. So before we move on to some more topical type questions, I do want to ask this question. What would you like people to know about the Department of Justice and about your division that they might not know already?
Yeah, that's a really good question because I've been suing the government for most of my life. So I have a suspicion of the government in general. And so it was like crossing sides was a little interesting for me. But one thing I like to tell my lawyers is, and part of what we do is criminal prosecution. So I've done numerous hate crime prosecutions over the last 10 months that I've been in office. What you learn, and I went to UVA Law School, I got a great education there, and I've learned from mentors who are former prosecutors, You know, it isn't just about using the overwhelming power of the federal government to dunk on potential defendants or the little guy. It's the Department of Justice, not the Department of Prosecutions or the Department of Winning or spiking the ball. So you're supposed to use that power, which is vast, very wisely, and we take that seriously at the DOJ. And so if someone in my department comes to me and says, well, you know, this looks like a good case on paper, except these are the flaws and these are vulnerabilities, and to get the best result, we might have to take a little bit more conservative tack of not going after all the things you'd like to do or whatever. And I take that seriously, you know, because we are here to do justice, not just to win. So it's not a zero-sum game, and I think everyone, our Attorney General has that same view. I mean, she is a prosecutor at heart. She never really worked in private practice until after she left the job of Attorney General, so she's a lifelong public servant. Mm-hmm. And she has that same perspective that we have to do what's right, not just what is like winning and losing and putting points on the board. And I really respect that, and that I feel comfortable with that. I think you have to know that, you know, it is a huge bureaucracy. That's the other thing that was alarming to me is like I come in and I'm head of two successful corporations, a nonprofit and a law firm, and I can really do whatever I want. Someone hires you on Tuesday, you file a lawsuit Thursday, have a press conference, have a motion for a temporary restraining order on Monday, and you might win that case in less than a week. That's not how the DOJ works. You have to write justification memos. So if you want to sue a state, the Attorney General has to sign off on that. So I have to write a memo to her, and sometimes I have to persuade her that, oh, the prison system of X state is woefully inadequate, and we're going to have to sue your friend, the Attorney General of that state. And so that conversation is had, and you have to be persuasive as to why that's a good use of government resources. And so there are many checks and balances within the Department of Justice is really what I'm trying to get at. And nothing happens off the cuff, and there are always many people involved in a decision, so it's a deliberative process. And now the public gets frustrated with that because they may see what they consider to be a federal civil rights violation happening, or misuse of police force or excessive force or whatever. Why hasn't there been a lawsuit, or why isn't there an investigation? Right. Well, to get to that point, you have to write justification memos internally. You have to work with the Department of Homeland Security or the Department of, or the FBI to do an investigation. You have to have the facts in place. And so we can't communicate to the public all of those background issues because as lawyers, we have ethical considerations regarding our investigations. We have deliberative process privilege. We have attorney-client privilege. And there are many reasons why we can't be transparent about all of our work. But there are always records internally, and if necessary, the Attorney General went in front of Congress yesterday. I've testified in Congress twice before oversight, the Senate, before oversight hearings. They summon you, and they can ask you questions, and you have to answer them. So we do that regularly.
Sometimes they're very difficult, as we saw
Sometimes
yesterday.
they're quite rude.
Yes.
Yes.
No comment on that. So let's talk a little bit about one of the cases that you are engaged with, at least at the inception right now. It sounds as though the DOJ may pursue litigation under the FACE Act for people who conspired to disrupt worship in Minneapolis. Can you talk a little bit about what the FACE Act is and maybe why DOJ is using it?
The FACE Act is a 1994 law passed, and the FACE stands for Freedom of Access to Clinic Entrances. And the initial purpose of the people who drafted and introduced this legislation was to protect abortion clinics from protesters. And it was fairly broadly construed law that says that if you're obstructing access to a house of, I shouldn't say house of abortion, a place of abortion, a place where abortions are carried out, but also all reproductive health care facilities, that's a crime. It's a misdemeanor in the first offense, and then second and third offenses have progressively harsher punishment. Now, this law was very controversial. To get this law passed, it was amended before passage to include houses of worship as protected places. From 1994 to 2024, the United States Department of Justice never brought a case involving protecting a house of worship until we had a case in West Orange, New Jersey, where pro-Palestinian and pro-Hamas protesters disrupted a religious ceremony, an event at a synagogue in New Jersey. They used these very obnoxious horns, the vuvuzelas that are used in soccer stadiums have been banned, in fact, by various jurisdictions. They blew them in the horns of protest of Jewish people trying to get to the synagogue event. And we sued under the civil provisions of the FACE Act the individuals who did that, as well as a couple of groups that organized the event. And we have further investigation ongoing into that. Now, in between that and the city's church event last month in St. Paul, Minneapolis, there have been several events disrupting Jewish houses of worship in the United States. Park East Synagogue on Lenox Hill, Manhattan is one. The Wilshire Boulevard Synagogue in Los Angeles, historic, beautiful synagogue. And then a few months before that, August Torah Synagogue in Pico, Orthodox Jewish neighborhood in Los Angeles. They were all disrupted by mobs that blocked access of parents dropping off or trying to retrieve their children from Jewish schools. And so we're investigating those cases under the FACE Act. And when the city's church situation happened, I was already very familiar with the FACE Act from our investigations and litigation, and it immediately occurred to me that this is very similar to what you saw the Biden DOJ, the Obama DOJ prosecute outside abortion clinics. You also saw the Biden DOJ prosecute at least one case that I defended at the 11th Circuit outside a crisis pregnancy center in Florida. There were 3 events where in a crisis pregnancy centers were attacked after the Dobbs decision, and they were blockaded, there was graffiti, there were threats made and left on the voice messages of 3 different, at least 3 crisis pregnancy centers. And in those cases, the Biden DOJ used not only the FACE Act, but also the Klan Act. The Klan Act, dating back to the 1800s, which makes it a crime for anybody to conspire to violate the protected civil rights of American citizens. So they converted first offenses of the FACE Act, which are misdemeanors, into felonies under the Klan Act. And they prosecuted people praying outside abortion clinics, and they prosecuted these Jane's Revenge protesters who vandalized crisis pregnancy centers. They did both, and we give them credit for that. And we defended that, and we won that at the 11th Circuit. So now that's the law in the United States. You can use FACE Act predicate acts to get felony convictions for conspiracy to violate civil rights under the Klan Act. Thank you, Biden DOJ, for setting that precedent. So now I'm using that in the city's church case because it's clear from the videos that were streamed by the participants before the event that it was planned, and now it was planned for days in advance. We know that from some of the GoFundMe that is being done by some of the people who've been arrested, saying, oh yeah, Don Lemon contacted me days in advance, and we, traveled there across state lines to do this event. And so the evidence is all out there to see. It was all out there on the Sunday that this occurred. And the Attorney General texted me, I texted her. We saw this unfold in real time. The evidence is out there put by the participants. So I think, we've indicted 9 people so far. I believe there is up as many as 40 people involved in this disruption of this church event. And we're looking for the rest of them, and we hope to bring them to justice.
Interesting. So I'm going to shift gears a little bit and talk about higher education. Now, FSU's leadership here is very effective and fair. We've got great leadership at this university, and I think we're all blessed to have that, to be quite honest with you. And our students are very broadly civic-minded here, but not all universities are so lucky to have that. And so I'm wondering, what are your priorities or your office's priorities as it relates to higher education, specifically in terms of admissions, faculty hiring, and anything else you want to discuss?
Well, it's a very important priority for the federal government, and it started even before I was sworn in as the Assistant Attorney General. This is one of the signature, I would say, first-year efforts of the Trump administration, because the amount of money that the United States puts out to our institutions of higher learning and K through 12 as well is massive. It's almost unfathomable. Now, we are world leaders in the we are leaders in the world on medical research and other areas, and I would say, waning, but in terms of quality of health care, because of the massive investment of the federal government in these areas. And so what we're seeing is students for fair admissions, and many cases like that where there's been persistent violations of our federal civil rights laws in many areas. It includes faculty hiring, and it certainly includes admissions. And so what we found is the user experience of tens of millions of Americans is you don't have a fair shot to be hired as faculty if you are conservative or white or male or any combination thereof. That would be very unfortunate. And if you're simply Asian or white, you are discriminated against in admissions. So these are facts that have been found by federal courts. And so we're aiming to right that because, as I said, this DOJ wants to be colorblind, and this administration wants to make sure that all Americans are enjoying the benefits of being American citizens. And so my first week in office, I think I wrote 50 letters to the top 50 institutions of higher learning demanding their admissions data, which is our right under the federal law.
Yep.
I also sent letters to top medical and law school admissions officers, and then we added a few other schools as well. My own law school alma mater, University of Virginia, ended up receiving 7 letters from me. Made me very unpopular in the, I wasn't really welcome at the Alumni Association events, and I also hadn't been writing them checks for a while, but anyway. But on the other hand, my alma mater, Dartmouth, had actually done a very good job of, I think, taking note of the shifting legal landscape, and new leadership had actually come in, and they really had no tolerance for the anti-Semitism that has been sweeping America's campuses after October 7th, 2023. And so I met with that president, and I thought she did a great job. I'm not, hardcore investigating that institution because I'm in touch with them, and they think they're doing things right. We have to recognize the success stories as well.
Yeah, that's right.
And I met with FSU's provost and president in my boss Pam Bondi's office because there was an anti-Semitism incident here, and they acted very swiftly to handle it and deal with it appropriately, and discipline the student who had been discriminatory to another student who was Jewish. So, again, we have to recognize those success stories.
Yeah.
So those are the priorities. We want to make sure that the American taxpayer, which is pumping billions of dollars, in some cases, I literally in the green room was on the phone with the president about one of these investigations that I'm doing, President of the United States. And we pump billions of dollars into some of these Ivy League institutions. And are they following the law? I would argue some of them are not. And so far, I've negotiated $500 million in settlements with some of the top institutions of higher learning, including Columbia, Cornell, Northwestern, and some others. And we've been successful in some and less so in some.
Yeah.
So
how do you stand? Sorry, go ahead.
And as I finish my thought is, what I will say is, the good news for taxpayers is, I would say that the public universities, particularly our elite public universities, have been much more rapid to change and adapt to the new legal landscape than some of the ivory tower type private institutions. So that's good news for taxpayers.
Yeah. I guess one of the questions I had here is, how do you follow up on this? Because, after the Supreme Court's Students for Fair Admission decision, everybody thought that the curtain was going to get pulled back, things would change. But I just looked at a study this afternoon that showed that over 10,000 faculty ads examined over a one-year time period from 24 to 25, and they found that 22.3% of them asked for DEI statements. And this is in what's actually published. Mm-hmm. And then at some universities on the coast, it was up to 43% of them. So this is a moving target. How do you stay on top? I guess this goes to the earlier question about how do you find out about complaints?
Well, it's difficult, and it's sort of a game of whack-a-mole, if you will. So we do rely on the public to flag these issues for us. For the education space, United States Department of Justice has primary jurisdiction over public employers, but the EEOC has primary jurisdiction over private employers. Sometimes we will get referrals, And then we will have to refer it over to Andrea Jacobs at the EEOC and vice versa. We have joint jurisdiction over the public employers. And there are over 6,000 institutions of higher learning that get federal funding. Just about every institution of higher learning, except for Hillsdale College, gets federal funding. And so, as a result, they're almost all of them have vestiges of DEI rhetoric on their websites. Some of them are blatantly persisting in doing that in defiance of federal law, come after me, so we're putting them in the line. But some of them have been proactive and they've hired counsel, and their counsel are helping them go over their websites and reform their practices to comply with federal law. The Department of Education Secretary Linda McMahon and I work closely together, and we speak regularly. And Linda has been extremely clear. You cannot use this DEI stuff to screen out hiring of faculty and admissions. It's not legal to do that. You can't force people to prostrate themselves on the altar of some political correctness in order to be eligible for a job. That's un-American and it's illegal. But what we have found is even some of the schools that are well-intentioned and hired counsel, their review of their website will find there are thousands of pages on a big university's website. FSU's website, I'm sure, has thousands of pages. It won't shock me if there's some vestige of something there that doesn't comply with the law. So what they will do is assure us, sorry, Ms. Dhillon, that it is on our website. It was when you called, and now it's not. And we're doing a comprehensive review of the website to take down any of those types of rhetoric. We have also found some institutions trying to be smart Alex, keeping the same faculty or the same DEI officers doing the same job, but changing their job description to inclusion office or something like that they think we aren't going to pick up. We are going to pick it up because there's thousands of whistleblowers out there who are telling us. And so we just constantly take in this funnel information. And I will say another great thing about this job is, and it's also the case in private practice, sometimes all you have to do is write a letter. And if you're a lawyer or you're the assistant attorney general, it does get people's attention, and you don't have to fire a shot in court. They will change their behavior and they'll stop it. And
that's a big stick. I
feel great about that because I've seen DEI programs in cities, in colleges, in hiring, in municipal offices, and they stop doing it after we send them a letter.
Interesting. So one last question for me, and then we're going to open it up for the audience to ask their questions. And here we've got Grant, who is going to be the individual who holds the microphone. He's a big guy. You want to ask nice questions when Grant has the mic. Last question from me is, what do you see as the most important challenge that you face in the next 5 years?
One of the biggest challenges that I faced so far, I'm going to give you a two-part answer, is the personnel in the Civil Rights Division. There are people there who are deeply wedded to their way of doing things. They never saw a police misconduct complaint that they didn't agree with. They never thought that white people or men were protected by our federal civil rights laws. So the good news is half of those people quit in the first week that I was there. So they self-deported. The big challenge has actually been hiring good people. So that is, if I were to say I hope my legacy is, I hope my legacy is that I'm able to hire enough good people who want to make their careers doing civil rights work the right way, looking at it objectively for all Americans, and leave that as a legacy. But every time you have a change of administration, things change, and the new president has a right to do that. But the Supreme Court has left us some landmark decisions that I hope we see the integrity of the court stay the way that it is and not see it stacked and packed and otherwise distorted, because I think they're actually a great check. I don't agree with many of the decisions of the Supreme Court. When I sued governors over 20 times to challenge COVID restrictions, the Supreme Court agreed with me in 3 cases and disagreed with me or didn't take up the case in most of those cases. I lost quite a lot. And that's how law is made. For every Brown versus Board of Education, There are dozens of cases that reached the Supreme Court where the court rejected it. The court did not take it up. And so every civil rights landmark decision that we've had is built on the bodies of failed cases. So I hope people continue to have the courage to challenge things that, including at the federal government level, that they don't agree with. And we butt heads sometimes with the Solicitor General's office. You know, they're very cautious. They like to have a very good win record.
Yes, they do.
And as a civil rights lawyer, I have to lose a lot of cases to finally get that nugget where I'm going to win. And the cases we won on religion at the Supreme Court at COVID were landmark cases. And one of those cases corrected an error in the prior jurisprudence that put religious liberties at a lower second-class status in the bucket of rights in the First Amendment and really elevated it back up to where it was supposed to be. So I lost a lot to get there. And so I think, again, we have to continue to be courageous, be willing to lose. And that's part of being a good civil rights lawyer. So I hope that that's what I leave as a legacy.
Excellent. Well, thank you for that. And at this point, I put a plug in. We now have, at the law school, we have a First Amendment law clinic here, and they are advocating for both religious rights litigants as well as for general free speech principles.
Wonderful.
So,
That's great.
Yes. All right, so now will be the time that we are going to open up to allow you all to ask some questions. So Grant here will bring the microphone your direction. So let's just kick it off here. You'll ask the question. I will sort of interpret it as best as I can for Ms. Dhillon. And Grant, we've got a question right up here first. You're going to get a workout, Grant? No. Right here. And why don't we do this? Why don't we just have folks queue up over here so that you don't have to walk around so much? All right, so Grant, stay where you're at when you're done, and people will queue up over there. If you want to ask a question, you hand it over to Grant.
Thank you. Good evening. So I would like to ask a little bit more about amicus participation, because in my research on the Civil Rights Division, I've seen trends in the amount of amicus briefs filed and also in the percentage of time that the Civil Rights Division supports the government. And this changes based upon administration. Do you know why this is occurring?
Yeah, so there's a lot of research actually on amicus participation when the U.S. gets involved, how people lobby to get the U.S. involved in certain things. So, I mean, what are the factors that you all look for when you're making a decision, and how much give and take is there with the parties?
So this little known fact about the Civil Rights Division is that the vast majority of the work that we do is suing state and local governments. Almost all of the work that we do is suing state and local governments. And so certainly I have authored and co-authored numerous amicus briefs in my 10 months. I've sat in the United States Supreme Court and seen better lawyers argue those cases than me, Solicitor General's office lawyers, the best oral advocates in the country. Those cases include Louisiana versus Calais, the Tennessee Hecox case, I think it was West Virginia and Tennessee, and Hawaii, the Hawaii case recently involving
the gun case, yes.
The gun case. Those are at least 3 of the cases, and there have been some others that I haven't had time to go watch the oral arguments. But we were suing the government in each of those cases, or in the cases of 2, our amicus, the boys and girls sports, we were supporting the state laws in those cases. And one was an equal protection challenge, and one was a statutory challenge. So I think it's mixed in the Civil Rights Division. I can't think of a lot of times that we have been, in my department, supporting the government, but there have been a few. Wyoming voter ID case is one where we did support the government. And so I don't think it's any mystery. It's like, what is the administration's policy? But even then, not every case is a good vehicle. So sometimes I lose that argument with the Solicitor General's office. I'd like to get involved in a lot more cases than we do.
Right, yep.
And they're like, well, you know, this is not the best vehicle for this particular thing. And when you listen to the Hecox case being argued by Hash Mupin, the Deputy Solicitor General, you would not even know the case was about boys and girls sports.
Right.
The case was about tiered scrutiny analysis and the extent to which a as-applied challenge to a statute really converted the intermediate scrutiny into a strict scrutiny analysis, and like very nerdy. So a lot of people probably couldn't even tell what side the United States was on from that argument. But so I think the trends are, this particular Solicitor General has a good relationship with my principal deputy. They both came from Missouri. And so my guy just walks down the hall and talks to him and tries to persuade him. And that's a good relationship we have. But they pick and choose. They're very selective. And when the United States gets involved, it's like they call the Solicitor General the 10th Justice. So they're selective. They aren't just, even the White House may want Solicitor General's office to take a position on something, and it, you know, they certainly are very persuasive, but they're also very protective of the integrity of the office, and they're not going to make arguments just because somebody wants them to politically. Yeah. It has to sort of fit with jurisprudence, and they have a big picture approach as to what cases are going to shape the law in this 3 more terms of the Supreme Court.
One of my students is actually here in the crowd, and the class that I'm teaching right now is on the Supreme Court's current term. Mm-hmm. And we take a handful of cases currently at the court, read the briefs, read the precedents, and we listen to oral argument. And we've heard some very good attorneys so far. I think Mupan did a fantastic job. There are some attorneys that just knock it out of the park every single time. I mean, Paul Clement is always amazing at what he does. And some of the justices ask very, very good questions. Some are better than others. I mean, I think Justice Kagan asks some really insightful questions. Justice Gorsuch is almost always spot on. It's very interesting to hear them and just watch how the law develops internally throughout those discussions.
Yes, it is. And some of them ask trick questions, and some of them ask layup questions, and some of them ask very fascinating questions, and some of them have a few phrases that they use, and if you were blindfolded but you just read the transcript, you could tell which judge asked that question, if you're a repeat player in the Supreme Court.
Yeah. All right, we have another question, I think.
Free speech and the internet. So in the Packingham case, the Supreme Court acknowledged that social media is the new town square. And I think that's a good thing because it provides access to more speech, but it's also a bad thing because social media platforms don't have to follow the First Amendment. And we've seen kind of some issues come up with their content moderation policies and who can access that speech. And I'm wondering if you see a way to rein in that monopoly on speech, and do you think that Justice Thomas's suggestion to treat them like common carriers is a viable option?
Yeah, that's a really good question, and I think the phrase you're referring to about the town square is really, it's kind of color and rhetoric. It isn't really a holding of the case as such, and I personally have been very frustrated because I'm one of the lawyers who pioneered suing social media companies in the last few years before I took this job. I filed 2 cases challenging what's now X, and then Twitter. One was for Megan Murphy, a feminist from Canada who used the wrong pronouns for a trans activist there who was forcing mainly immigrant women to wax his genitalia. And, you know, this was a violation of Vancouver's human rights statute to refuse that service. So she's a feminist who's standing up for women, and she referred to this person as him, and got kicked off permanently from X for doing that. I sued X, and X, then Twitter, used Communications Decency Act, Section 230, as its defense. I disagreed with that, but I lost that case. Another is a case of Rogan O'Hanley, who is a conservative, goes by the name of D.C. Drano. He made remarks about the 2020 election, and as a result was censored by, removed from Twitter as a platform as well. We took that case up to the Supreme Court, and the Supreme Court declined cert in that case. But it did take up in that same term Missouri versus Morthy, and then kind of choked on answering that question as to whether and what would have to be done to prove that the government discriminated. I think it's very clear in 2 of these cases, Rogan O'Hanley's case and Missouri versus Morthy, that the government clearly discriminated. The government compiled lists. The government hired vendors to draw up lists of bad people. I was one of those people in the Missouri versus Morthy case. I was one of those people who was viewed as an election denier by the federal government, and therefore my social media presence was almost certainly throttled by social media companies in response to the government's heavy hand. We'll never know how much speech we didn't see during COVID and after the 2020 election because of that. So my conclusion here is that you're not going to see the United States Supreme Court really go out on a limb on this issue. They're not comfortable with it. I have testified in Congress about it, and I'm just saying this in my capacity as a private citizen because, of course, I'm not certainly saying anything about another branch of government now, but CDA 230 is a 1996 law that was designed to open up the internet for nascent telecoms companies that were getting into email. I mean, I remember having to use dial-up when I was a young lawyer in my Manhattan apartment, and the little wagon wheel, and it was as noise would come, and you would send emails to people. There was nothing like social media companies. So it is way past time, in my capacity as a private citizen, for the United States Congress to revisit Communications Decency Act Section 230 and other digital telecommunications laws to update them. Because in my opinion, and the arguments that I made in that case, these cases were that where you're simply allowing people a platform to send emails to each other, of course, you should have immunity for that. When you're filtering content based on political viewpoints, you are acting as an editor and not a content carrier, and different rules should apply. What those rules should be is for wiser people than I, but I do not think the United States Supreme Court, having a very good case in Missouri versus Morthy, if they didn't take up that case, which I think was a slam dunk, I don't think they're going to take it up, so I think the law needs to be changed to see some reform in that regard.
What about tort options, intentional misrepresentation, or maybe some contract claims for violating their terms of services to folks? Are those options?
I mean, I have testified in Congress that there should be a Internet Users Bill of Rights, where if certain things happen, you should have a private right of action. Now, private right of action is actually anathema to most conservatives. They think, tort lawyers are bad people. I'm able to do this job because I'm a successful tort lawyer. So I appreciate the tort laws. But I think that's one way to go. But, you're seeing a whole brave new world out there. I think there's some interesting questions about tort law vis-a-vis AI and AI defamation and AI porn. And I knitted a hat for a friend yesterday, and there are multiple images on the internet of President Trump wearing that hat and Melania Trump wearing that hat, digitally generated versions of that. And so, there are laws in some states, including California, about right of publicity. Mm-hmm. And suddenly AI is simply hijacking people. I'm a big fan of Victor Davis Hanson. I listen to his podcast. There are fake podcasts out there, thousands of them, using his voice and his likeness and simply spewing opinions that he doesn't agree with. Is there a private right of action for that? There ought to be. It's defamation. Right. But I don't think the current law really fits this brave new world. So it's maybe less grandstanding from the folks on Capitol Hill and more making of laws. That would
Good luck with that.
Fit the bill.
Indeed. All right, another question.
Evening. I was just kind of wondering, you mentioned the Patriot Act, like your dislike for the Patriot Act back in 2001 and your respect for privacy. What are your thoughts as a civil rights specialist on immigrations and custom enforcement doing search without the use of a warrant?
So I'm not going to get out beyond what our current administration position is, and even with respect to the Patriot Act, we had Attorney General John Ashcroft come visit our offices to say hello to us and speak to us, and he told me he disagreed with my views on the Patriot Act, but and we had a vigorous discussion about it. So that's a difference of opinion. Now I'm in the law enforcement side. I think the law and our administration position, as articulated in many court cases on the question you just raised, is very clear. We believe that those warrants are not required, only administrative warrants are required. And so that's the current state of the law. And so I'll just leave it at that.
Thanks. Question about social media. You talked about your use of social media earlier and a lot about how the government can kind of fight against the little guy. I'm curious how, I saw your Twitter fight with Ed Whelan a few weeks ago. I'm curious how you think that if someone is maybe having a case with the DOJ, but then anyone within the DOJ is personally going after them on social media, how they don't think either A, they can be retributed against if they're being sued by the DOJ, or B, if they're trying to take a case up against the DOJ, then they might get a fair shot because within your own personal capacity that you may be attacking them.
Can you reframe that for me? I don't think I
Yeah,
quite followed the question.
Right. So I think the question was how, as a government entity sort of dealing with social media, can you separate your own private use of social media versus the public use of social media, and should that play a role one way or the other?
Well, the administration's position is, so first of all, people who are confirmed by the Senate are, presidential appointees. We're not quite the same as other employees, but even within employees who are rank and file employees of the Department of Justice, there's very well-developed First Amendment law on what you can do and what you can't do in your off hours and your private time versus what you can do as a, employee. You can't contradict your employer. You can't be insubordinate or contradict your employer's position. You have the right to go out and campaign for people your boss doesn't agree with on your private time. And there's a famous case involving the distinctions that has to do with Harry Connick Jr.'s dad. Harry Connick Sr. was a law enforcement official. I think it was the United States Attorney or District Attorney in Louisiana. And there's an employee wanted to wear a button at work and advocating for a particular person to win an election, and that's not allowed in most law enforcement workplaces because you're supposed to represent the whole public. Can you go do that on your private time or weekends? Absolutely, but can you do it at the workplace? Probably not. So I think where I see this question come up quite a bit is dating back to the first Trump administration. There was a case involving the president blocking people or saying things to people. It was brought by, I think, a law school clinic in New York, NYU Law School Clinic or something. That case is not really good law anymore, in my opinion, because it was mooted on appeal because the president was no longer the president. And so, but the advice I've given in private practice to public officials is, in your public account, to be on the safe side, if you were following that precedent that says, oh, the president can't block people or public officials can't block people, you probably shouldn't in your public account. But in your private account, you can have a private life and a public life. So I will tell you, I get death threats and I get very vicious things said to me in social media, and my private account, I don't think I have to watch that and see it. My public account, I don't read every comment because people say all kinds of crazy things. So, public officials are human beings as well. So, in terms of a tort claim, I think you mentioned tort claims somehow. Look, I'm a big believer in the First Amendment, and generally speaking, you can pretty much hardly sue anybody for nasty things they say to you. You just have to deal with it in different ways.
Yeah, there's really two parts to this question. Yeah, the first is, do you think that free speech rights completely override facts and truth? Okay, and then the second part is, as we all know, Donald Trump, in fact, did lose the 2020 election, but nevertheless, he claimed that he didn't and the election was stolen, and he carried out various activities which were obviously illegal and unconstitutional.
Okay.
Okay?
So interesting question. First Amendment and opinion versus fact. You want to take that up?
Yeah, first of all, I'm going to reject various of the tendentious framing of that speech/question. But the premise about facts versus speech, I never want to see this country become the UK, where people show up at your door and arrest you for having, unpopular opinions, or frankly, very popular opinions that are out of favor with people with power. And I'm with J.K. Rowling and others in the UK who believe that you should be able to say that a man cannot become a woman and vice versa, and that should be your right. So that is a decision that the founders of this country made early on, is that they would rather err on the side of free speech, free press, freedom of assembly, freedom of religion, and freedom to petition the government, even if that errs on the side of wrongthink and views that we obviously don't agree, people who think they're more educated would disagree with. So nothing is obvious to me. I think there's anything wrong with asking questions. And the beauty about the First Amendment is if your answer to speech you do not like is your own speech and other platforms. And that is one of the great developments of the modern internet, is that you can get your views out there very easily now, and I think that's good. You have to be careful,
Right.
but I don't really see the problem, frankly.
And maybe just a follow-up with the why, right? And the why question is about intellectual humility, to understand that we're not always right. What we think is truth sometimes is not, and we need to make sure that we appreciate that. So how does that notion, that principle come into play here with the First Amendment?
Well, if it's impossible to utter wrongthink, then you're never going to be able to change people's views or persuade or even learn anything yourself. I mean, I have been persuaded to change my views on a host of issues over the years by simply engaging with people who believe differently than me. I have very close friends who disagree with the administration's position on what's happening in Minnesota. And they reach out to me, and I hear them. And at a minimum, I'm informed of public opinion about these issues, which I think is actually helpful to doing your job as a presidential appointee. It matters. Perception is also important, as is reality. And so I think that's helpful to know what people are thinking. I wouldn't know that if our government was fascist and simply shut down viewpoints, or if I were intolerant and didn't hear my friends or even members of the public who have things to say about what I'm investigating and what I'm not investigating as the chief civil rights officer of the United States. So I think that is a hallmark of an egalitarian society, is the ability to exchange different and sometimes even controversial views. And and I've traveled in more than 50 countries, and I come from another country. This is the last bastion of free speech in the world, really. I mean, when the UK has fallen, Europe has fallen, the offices of X are raided in Europe and other countries. In India, where I was born, news about widespread millions of farmers protesting over new controls on prices of commodities were suppressed in India. You couldn't read about that. I could read it here, but you couldn't read about it in India because the government said you couldn't see it. That's a democracy. That's the world's most populous democracy. So it is the most important fundamental of our rights, the First Amendment.
So on that notion of intolerance and tolerance, I'm going to put one plug in. Our data that we've collected, we poll pretty regularly, and our data at the IGC showed that there is a strong correlation between people who have greater civics education and a decreased propensity to engage or support political violence. The
Okay.
more civics education you have, the less likely you are to be politically violent. And so as we talk about things that we can do to improve society, I think one of them happens to be greater civics education and greater awareness about the principles upon which the country was founded and why those principles have endured. So we are out of time. We're going to have to leave it at that. I apologize to those of you who have been standing in line. It's a testament to the fantastic speaker we have here this evening. So Assistant Attorney General Dhillon, thank you for being here. And if you would, please join me in thanking her for being here.
Thank you.